welcome to Unjustified, where we always cover the truth, the facts, the good, the bad, the ugly, on an unbiased and sometimes very unpopular opinion. I've been asked recently a lot about the new phone call that has been leaked from Chris and this unknown male that has been said to be an attorney by some that he's talking with. I don't know that because his name was never mentioned in the call, so I don't know. So I call him the unknown male. He sounds a lot like Dr. Phil, oddly enough, doesn't he? If you've heard it, you'll know that. And even if you haven't, what I did is I went ahead and I made a transcript of that call because sometimes Chris is kind of hard to understand, and there's even a few words that I couldn't understand after rewinding and re-listening and rewinding and re-listening, but I done the best I could and I made a transcript about it. But a lot of people has been asking me, what exactly is this? What does this call mean? Is he getting an appeal? I heard he's getting out. Is he this? Is that? So I decided to go ahead and do a little bit of homework on it and what he's actually asking for and wanting to accomplish with this after listening to the phone call and making the transcript. So I decided I would just share with you guys what the actual law is on these things that he's wanting to try to accomplish here. And then I will also, after I explain them out here to the best of my ability to you guys and show y'all what I'm talking about, then I will also play the recording and with this transcript that I made for it. So please overlook the question marks in the transcript, because when you see the question marks, it's just something that Chris said that I really just couldn't make out. I really did try though. So one of the first things that I heard that he mentioned in this was the 35C motion and also the Brady. What I'm going to try to do here is explain to you guys what both the 35C is as well as the Brady Rule, so you maybe can get a little bit of a better understanding of what grounds Chris believes that he is eligible. Okay, the Brady Rule requires prosecutors to disclose material exculpatory evidence, and what exculpatory evidence would be considered is evidence such as a statement tending to excuse, justify, or absolve the alleged default or guilt of a defendant. In the government's possession of the defense, a Brady material or evidence, the prosecutor is required to disclose under this rule includes any evidence favorable to the accused, evidence that goes towards negotiating a defendant's guilt that would reduce a defendant's potential sentence, or evidence going to the credibility of a witness. If the prosecution does not disclose material exculpatory evidence under this rule and prejudice has ensued, the evidence will be suppressed. The evidence will be suppressed regardless of whether the prosecutor knew the evidence was in his or her possession, or whether or not the prosecutor intentionally or inadvertently withheld the evidence from the defense. Further, in cases subsequent to Brady, the Supreme Court has eliminated the requirement for a defendant to have requested a favorable information, stating that the prosecution has a constitutional duty to disclose that is triggered by the potential impact of favorable but undisclosed evidence. The defendant bears the burden to prove that the undisclosed evidence was both material and favorable. In other words, the defendant must prove that there is a reasonable probability that the outcome of the trial would have been different had the evidence been disclosed by the prosecutor. So, obviously, Chris believes that the prosecution did not hand over important evidence to his defense team that they would be able to hand over in court or in a trial. There wasn't a trial, so now another reason he feels he is entitled to this appeal, to file this motion 35C, is, and what the 35C rule actually is, and as you'll see, it is actually not an appeal. It says, the Rule 35C of the Colorado Rules of Criminal Procedure allow defendants to raise certain claims in the trial court even after they have been convicted and exhausted all of their direct appeal rights. Such claims are called collateral attacks. For example, a defendant may believe that he has located important new evidence that was not previously available to the defense that would have changed the outcome of his case. So see, he would have to prove and show new evidence, and that could or would change the outcome of his case, or may come to believe that his attorney did not provide adequate representation to him during the pendency of the case. Claims like these may be raised under Rule 35C, even if the case was appealed in the regular fashion and that appeal was unsuccessful. Not every type claim can be raised under Rule 35C. The rule does not establish the right to retry the case, nor to raise issues that very limited exceptions were previously decided or could have been presented as part of the initial appeal. Issues that may be raised under Rule 35C are limited to significant changes in the law, constitutional violations in the statute or underlying the conviction or sentence, a lack of jurisdiction by the trial court that heard the case, newly discovered evidence, any other grounds properly for basis for collateral attack, or claims that the sentence has been fully served. So out of these, from what we gather from the phone conversation that he had with this man, as well as him wanting to also have the Brady law, I would say out of these 6 issues that can be raised under this rule would be his constitutional violations in the statute or underlying the conviction or sentence, and newly discovered evidence. Any other grounds properly for basis for collateral attack, because I'm not sure where the significant changes in law could come in, and I'm not sure where a lack of jurisdiction by the trial court that heard the case, that wouldn't be a part of it, and definitely not claiming that his sentence has been fully served. So it would have to be the new evidence, collateral attack, constitutional violation. Time limits to file a motion. There are time limits within which such claims must be brought. There is an interest in having some finality to decisions of the court, and there is a cost involved in litigating these claims, especially as more and more time passes since the conviction. Therefore, the legislator passed a statute of limitation on collateral attacks and required that a person bringing such attacks, including motions pursuant to Rule 35C, do so within 3 years of any felony conviction other than for a Class 1 felony, 18 months of a misdemeanor conviction, and 6 months for a petty offense conviction. So Chris did mention in his call that he only had 1 year left, I believe, he said, to file this. Well, actually, that's not correct in this, because if you have a Class 1 felony, you can file this motion at any time. There's no limit to it. I'll show you what I mean going on down. There is no statute of limitations for collateral attacks involving a conviction of a Class 1 felony. Motions presenting collateral attacks that are filed after the time limits must be justified by a specified exception, such as the court lacked personal or subject matter jurisdiction, or the failure to file a timely motion was due to justifiable excuse or excusable neglect. Specified time limits to attack a prior conviction. Colorado revisited statutes provided that a person who has been convicted under a criminal statute in Colorado or another state may collaterally attack the validity of that conviction only if such attack is brought within a specified time period or completion of the direct appeals process for that conviction, unless one of the exceptions listed are applicable. The specified time periods are as follows: all Class 1 felonies, no time limit; all other felonies, 3 years; misdemeanors, 18 months; petty offenses, 6 months. Okay, it says, what are the grounds? 7 common grounds for post-conviction relief under 35C include: the defendant was illegally convicted or sentenced; the law under which the defendant was convicted is illegal; the defendant's conduct was legal; the court did not have authority or jurisdiction over the case; there is new evidence of material facts that could not have been reasonably discovered prior to the conviction; the sentence has already been fully served, or there has been an unlawful revocation of parole, probation, or conditional release, and or other grounds called collateral attacks, such as ineffective assistance of counsel or misconduct. Okay, so I'm only seeing 2 or maybe 3. He could be going under 3. He could be going under he was illegally convicted or sentenced because of some of the things he said in his talk with this attorney or man. Also, the new evidence, material facts that could not have been reasonably discovered prior to the conviction. Well, that's highly likely because the investigation was very quickly done, but now it does say material facts, so that would mean materialistic. It would have to be something that is physical form. I'm assuming that's what that means, not like just hearsay, They would have to show this proof and evidence. And also maybe the collateral attacks. He maybe could fall on those grounds, or he thinks he can. And then how will the judge decide? Well, it says there is no way to be sure how a judge will rule on a 37 or 35C motion. The judge in the case has the discretion to grant a 35C petition if he or she believes doing so serves the interest of justice. Some of the factors the judge may consider include whether the motion is timely, whether the motion states adequate factual or legal grounds for relief, whether the motion states legal grounds for relief that are meritorious, whether the motion states factual grounds, even if true, entitle the party to relief, and whether the files and records of the case show to the satisfaction of the court that the defendant's factual allegations are true. If the court finds that a defendant is entitled to post-conviction relief, the judge has several options. Depending on the case, the judge may vacate the judgment and or grant a new trial, or the judge could impose a new sentence and or discharge the defendant. When will the judge decide? If the judge decides to deny the 35C motion without a hearing, he or she will issue a written denial within 63 days. Well, this phone call we're hearing took place on September the 11th. The man talking to him said it wasn't going to happen overnight, but it should be within the next day or so or a few weeks. So there's that, and I don't know. We haven't I mean, that's all we know. Of course, is this call. If the judge wants to hold a hearing before deciding on the motion, the entire process takes longer. First, the judge will order the prosecution to file a written response within 35 days. Next, the defendant may file a written reply to the prosecution within 21 days. Then the court will hold a hearing where both sides may present arguments and evidence. Finally, the court will usually make a final decision within 63 days of the hearing. What are other forms of post-conviction relief? 1. Appeals. The defendant may appeal a guilty verdict and or sentencing to a higher court. No new trial is held. Instead, the higher court reviews whether the lower court made any mistakes. The deadline to appeal is 35 days after the judgment, so that definitely would not be something he could do. Number 2, motions for a new trial. Defendants who believe they received an unfair trial may file a motion for a new trial. If the judge grants it, the verdict will be set aside and a new trial will be scheduled. The deadline to file 14 days after the verdict, unless new evidence surfaces. Motions for reconsideration. Defendants who believe their sentences were too harsh can file a motion for reconsideration. Depending on the strength of the defendant's arguments, the judge may impose laxer penalties. The deadline to file is 126 days after sentencing, so that would not apply either. Federal Writ of Hc. This is similar to a 35C motion, but in federal court, the deadline to file is 1 year and 90 days after the Colorado Supreme Court denies the defendant's petition to appeal. However, this time limit is put on hold if the defendant filed a 35C motion as well. Note that defendants may also appeal the denial of a 35C. If the petition is denied, can I file another one? Yes, but the court will deny it unless it contains new information that was unknowable when the previous 35C motion was filed. So that said, in order for Chris to even file this motion, or even for an attorney to file it, they're going to have to know for certain that he has some hardcore evidence and proof that he can prove that he is not guilty of this. Even though he has already confessed to it, obviously there's some of this conversation that's not here, because when Anna came up, and you'll hear it, and she says, "What were you talking about before we were cut off?" And about the evidence, and I'm not even going to go into it, but you're fixing to hear it. But anyway, he's obviously got some hardcore evidence and proof that he can turn over without any doubt in his mind or this attorney's mind that will prove his innocence. The attorney also says people confess all the time to things they're not actually guilty of, because they're just telling them what they want to hear so they can get out of there, but that's not what happens. Well, that's what it sounds like's going on with this phone call. It sounds like, to me, that whatever they were talking about in the part that we didn't hear, and I don't know, but that's what Anna said, they had got cut off, and it was right before they got cut off that she said Chris was talking about this. But obviously, Chris believes, and this attorney believes, there is hardcore evidence, and he has them, that he can present to a court now, or a trial. He is ready to talk. He says that. He's ready to tell them everything, but he don't know if he should tell them everything right yet. But he feels like he's got the proof to prove his innocence. He also brings up the fact of when they came to the prison to talk to him. He says he knows they're going to use that against him, even though, I guess he was just saying it to clear Shanann's name or whatever, I don't know. But in order for him to file this motion, there has to be evidence. There has to be proof of material evidence. And also the Brady Law, there again, he's got to have evidence as well as he feels like he wasn't given a fair trial or he was misrepresented. So yeah, there's a lot going on in this call. It's just Chris is kind of hard to understand. And then to put it all together and wrap your head around what exactly he's going for here and this attorney's going for him, because the attorney straight says, you know, if they tell us no, we'll do it again. We will not take no for an answer. So obviously there is some hardcore evidence out there that he is wanting to turn over now because he wants out. So whatever it is he hasn't told, he believes he can prove it. So that's what I get from this call. I'm going to go ahead, and I did take a few hours trying to transcript this out for you guys since he's so hard to understand. And I'm going to go ahead and play that clip for you.
Not too bad. Thanks for taking the call.
Yeah, is it just you, or is Anna on also?
I'm here too.
All right, cool. All right, so just talk to me. I don't want to be the one monopolizing the conversation. So tell me what you want to know from me, or just tell me what's on your heart.
Well, just going in the law library as much as I have, I see a lot of cases. I've heard a lot of cases around here, guys. I've seen a lot of cases where the DA or the judge have had a lot of misconduct, but the judge has ruled, say, well, it's not egregious enough, or it's not that that wow factor enough to really sway in the defendant's favor. Now, I'm looking at the things that I know. I mean, I've never dealt with a law before, but all this. I mean, I'm winging it in the law library as I am, and God directed me through little things like through the poisonous tree, the Brady Law, and different cases that just they pop out of nowhere. But I know if God is putting it in front of me, and I see all these things that relate to my case, I just don't know how to frame this. Where like when I do this 35C, I've had this paperwork with me for probably a couple months, and I know I only have a year left to appeal some of those Class B and C felonies at a 3-year limit or 2-year limit, and I really want to figure this out where I can do it in the right time frame, but also not rushing anything. And I just want to get out of here. I know that God has a plan for me, and it's to be in prison right now, but it's not to stay here. Because He brought me here for a reason. But He also wants me to do something on the outside. I know I just can't sit here and just wait. I know there's waiting, doing nothing, and there's waiting that I'm seeking an action verb. That's what I'm doing. But I also want to know what action to take, because I have no intellect when it comes to the law. But I know He can teach me, and that's what I'm just waiting for. Things that fall into place, I just don't know how to do it.
I got you. And you don't have the benefit of an attorney that is in your hip pocket, so to speak. Okay, I've got a couple of attorneys here I can talk to that can maybe help get some good results, get some good advice for you in terms of forms and what to say, things like that. That's not going to be an overnight process for me to get the results we want. It's going to take some time, but I'm not saying overnight, but I am saying maybe several days or a week or so. So let me see what I can do along those lines. Because I know you're in a tough spot, and it's how do you know how to do something when you don't know what it is you need to do? So it's tough. So I get it.
It's trial by error thing, but I know with the law it's like, all right, you're gonna run into certain things where the motion's gonna get denied, or whatever I write down, the judge might think, well, that's not what you're claiming isn't enough to go back to. You're not warranted a trial. You're not warranted to have this appeal granted. denied. And I was like, well, what do I do then?
Yeah.
And I don't want to get, disheartened when that happens. I know it'll probably happen at some point, but not all motions are all appealed or granted right off the bat. That's why I want to make sure I write this the right way. When it goes there, they see like, oh, well, like, do I put everything down that I know? Or just like, I don't want to put everything down so they know everything that I'm on,
Well, okay, let me address a couple things in what you just said. First of all, you live in a closed society now. Every door is shut in your face. You cannot go from one. You go to one wall, you can't go further. You got to turn to your left, you can't go any further. So you know what I'm saying? You're in this perpetual this room with no door, so you cannot get through. You got that? You understand that? What I'm trying to say? So your world is controlled. You hear the word no probably more than you hear the word yes in that system. So one thing you need to be very accustomed to is being denied, being turned down, being told no. You with me?
Yep.
Okay. Now, some people will lose hope very, very quickly because everywhere they turn, every time they talk to someone, they're hearing things they don't want to hear. They're being told no. You can't do this. You can't have that. You can't go here. You can't go there. Whatever legal action you're trying to do.
Attorney's calls may be monitored and recorded.
Whatever you're trying to do, you're always being told no. What you can't do is allow yourself to lose hope. Don't take no for an answer. And don't give up the first time you're told no. You understand?
Yeah.
So the key in all this is you got to be strong. You got to be physically strong. You got to be mentally strong. And you've got to understand that, you know what? You're the underdog, but underdogs can win. They can be a dog in the fight. So I want you to get this attitude that no matter what you do, we're not going to take no for an answer. They tell us no, we're going to try again. They tell us no again, we're going to try again. You've just got to keep persevering and don't lose hope, okay? Because I tell you what, you lose hope, you lose your life. All right? So just keep a positive attitude about all that, and don't take any steps back. Just keep moving forward. Even if it's a small step, move forward and not backward. Okay?
Okay. Just like in my devotional today, it was Esther. It was a door of hope, and the Lord was speaking to Esther, and she was saying to the Lord, I've led you to the wilderness, but I will plant in that wilderness vineyards. If you go through the valley of Kor, which is the valley of trouble, I will put a door of hope. So even though you're in a wilderness, you're going to plant vineyards in that wilderness. Though you're in the valley of trouble, there's going to be a door of hope in that trouble.
That's great. Well, I'm proud of you. Good job. Keep that up. Keep your nose in that book too.
I will.
Yeah.
So, Chris, what were you saying before we got cut off about when he asked, I can't remember what it was, but you were talking about the evidence and your confession that wasn't true.
Well, I just know that I've never experienced anything like this before. Like from the tragedy that happened, from the law enforcement to the interrogation, the jail, the prison, all this was new. All this was new. And I know that even though I've never had something like this happen before, I knew the shock and the trauma was there in my mind. I didn't know how to process it. Every question that they asked me, I was just agreeing with them and just going along with what they said, because I was like, well, I guess we got to tell them something. And even when they came here to prison and interrogated me, they were in their street clothes acting like they didn't, they were just talking to me, when in retrospect they were actually interrogating me again. And I know for a fact that, that interrogation and I used, because coercive type psychological intimidation of someone that, had never been in that situation before, and they just use that to their advantage.
Well, Chris, what you witnessed firsthand is is a game. It's like getting back to the old biblical days where you've got the big Roman soldier in the pen with the little guy, and you're fighting for your life, and you don't know what to expect, but that's a terrible analogy, and I'm sorry, but I'm just saying, you just didn't know what was going on, and it's a game. That's what I tell so many people. This is a game that they're playing. You are the prey. They're the hunter. You're the prey, and they've got you exactly where they want you. And most times they're going to get what they want, because you know what? They keep you for hours. They deprive you of your basic needs. And as every second that you're with them in that chair and they're bearing down on you, your mind is actually deteriorating. Your mind is playing games against you. And that's why we have so many times where people give confessions for things that they just did not do. And it's because, you know what? They want to get out of there. They want to just tell them what they need to know, what they're asking, what they're interested in, so they can get out and go home. Well, you know what? Guess what doesn't happen? They don't go home. And their life is forever changed. So it's...
After I told them what they wanted to hear, then they offered me food.
Exactly.
So strange. But the thing I know, like where you're talking about playing a game, is when the TBI agent and the FBI agent, like when the TBI heard the woman, when she questioned me for hours, and then after those hours of interrogation, she puts me on a polygraph. And then I'm exhausted at this point. And then after that, I'm sitting there alone, and I hear them. It's the film intercom doesn't pick it up. I hear them outside the door. The FBI agent comes up. Oh, how did you do? And she said, "Oh, he did pretty good, but I think we get some more out of him." And they come in with this game face, saying, "Okay, you lied." I'm thinking to myself, "Wait, I thought you just said it pretty good." And I didn't question about it. I just believe what she said, and they said I made it. But I know for a fact she said, "You did pretty good, but I think we get some more out of him." I'm just like, I'll only think about this stuff way after it happens.
All right, Chris.
Wow.
Chris, that's a little game, and I can tell you for a fact that they did not administer the polygraph in the proper way. You should have been on the top of your game, mentally, physically, spiritually, when they gave you that polygraph. You should have had a good night's rest. You should have before they gave you that polygraph. So I don't trust the polygraph. I don't trust the results, and they use that as a hammer over your head to scare you, because the polygraph scares everyone because of its reputation. We can talk more about that later.
Yeah. Well, thank you for taking another call. I think got 30 seconds left, but I know that God can lead me on how to write this thing up to get it back, and I just thank you for helping me and just going into that discovery. I mean, you don't have to do it, but you're doing it, and I just believe that you got some information on your heart that's really gonna break this thing open too.
Good. We're with you.
All right, he got cut off.
All right.
And just tell me what you think. I'm also going to be coming up really soon, like tomorrow. I'm going to give you guys my own review of the Netflix documentary as well. A lot of people's asked me what I thought about it, and so I'm just going to give a little review on it since everybody else is. I will too. You guys have a great night, evening, wherever you may be, and until next time, this is Unjustified.